You are watching PR English Shorthand Dictations YouTube channel.
This is English shorthand dictation number 419 and the dictation speed is 100 words per minute. Ready? Start. The learned senior counsel, appearing on behalf of the appellant, stated that the appellant is the constituted attorney of Reena Natekar and Sanjay Natekar, the vendors under the sale deeds subject matter of the impugned FIR. He submitted that the fourth respondent in his complaint had accepted co ownership of the vendors in respect of the subject property under the sale deeds. Learned senior counsel submitted that a complaint was filed by the fourth respondent more than 2 years after the date of institution of the civil suit. Learned senior counsel pointed out how Sitaram Natekar became the owner of the subject property based on documents executed in the years 1928 and 1929. He submitted that Reena Natekar and Sanjay Natekar are the legal representatives of Sitaram Natekar. He submitted that both claimed a half share in the subject property in view of the regime of the communion of assets applicable in the state of Goa. He pointed out that on 10th May 2013, the appellant had published a public notice calling for objections from any interested party concerning the subject property. He pointed out that the ingredients of the offense of cheating under Section 415 of IPC were not made out. The submission of the learned senior counsel appearing for the appellant is that the registration of the impugned FIR was malified. He pointed out that the appellant, apart from being a businessman, is an active member of the Maharashtra Gomantak Party and is a member of the Legislative Assembly of the state of Goa. Learned Senior Counsel, representing the fourth respondent, submitted that the appellant tried to dishonestly misappropriate the property belonging to the fourth respondent, who is a resident of the United States of America, and sold the subject property to third parties. He has done that with the knowledge that the fourth respondent was a co owner. He submitted that the supplementary statement of the fourth respondent was recorded in the impugned FIR. Due to COVID 19, the investigation could not be carried out based on the impugned FIR. He relied upon a decision of this court in the case of Messrs. Vishakha Infrastructure Private Limited versus State of Maharashtra and others, and submitted that the investigation could not be scuttled by interfering with the FIR at the initial stage of the investigation. He submitted that an FIR is not an encyclopedia that can disclose all facts and details of the offense. He also pointed out that the consideration under the sale deed has been transferred to the appellant and not to the members of the Natekar family. He submitted that merely because civil suits are pending, that is no ground to quash the criminal proceedings, as the conduct of a party may amount to an offense and may also give rise to civil claims. He relied upon a decision of this court in the case of Amit Kapoor versus Ramesh Chandar, and another in this regard. The learned counsel would submit that an opportunity may be granted to the police to complete the investigation by upholding the order of the High Court. The learned counsel, appearing for the state of Goa, supported the impugned judgment and order. We have carefully perused one of the sale deeds, which is the subject matter of the impugned FIR. The sale deeds are similar. The appellant signed the sale deed as the constituted attorney of Reena Natekar and Sanjay Natekar, and also in his capacity as a confirming party. The said power of attorney executed by Reena Natekar and Sanjay Natekar in favor of the appellant contains a recital that Reena Natekar and Sanjay Natekar are the co-owners of the subject property. The legal effect of the sale deeds, which are the subject matters of the impugned FIR, is that the ownership rights of Reena Natekar and Sanjay Natekar were transferred to the purchasers. It is pertinent to note that civil suits were filed by the fourth respondent in October 2018. In the suits, he claims to be a co owner or person with an undivided share in the subject property. 2 years after the institution of the said suits, the constituted attorney of the fourth respondent filed a complaint with the Superintendent of Police on 23rd October 2020. In the complaint, she stated that the subject property was originally owned by the predecessor of the fourth respondent and Sitaram Natekar. It is pertinent to note that the constituted attorney of the fourth respondent has omitted to mention in the complaint that 2 years before the filing of the complaint, declaratory suits were filed by the fourth respondent which were pending. Interestingly, 2 years after the registration of the FIR on 13th October 2022, the fourth respondent filed a supplementary complaint with the police alleging that even the said Reena Natekar and Sanjay Natekar had also committed an offense. Thus, in short, the grievance of the fourth respondent is that the vendors under the sale deeds had only an undivided share in the subject property and they could not have sold the entire subject property under the sale deeds. The contention of the appellant is that what is sold is the right, title, and interest of Reena Natekar and Sanjay Natekar. Thus, the dispute between the parties is predominantly a civil dispute. It is pertinent to note that the purchasers under the sale deeds have not made any grievance about the sale deeds. In this case, it is impossible to understand how the appellant deceived the fourth respondent and how the act of execution of sale deeds by the appellant caused or was likely to cause damage or harm to the fourth respondent in body, mind, reputation, or property. The appellant has not purported to execute the sale deeds on behalf of the fourth respondent. He has not purported to transfer the rights of the fourth respondent. There is no allegation that the appellant deceived the fourth respondent to transfer or deliver the subject property.